name is John Cornicello, and I go live on Mondays and Thursdays with conversations with and about photographers and photography. Today, my topic of conversation is critical legal concerns for photographers in the current situation. My guests are Nate and Gabe from Hoerschelmann Dietz PLLC law firm. So please welcome Nate and Gabe.
Hey guys, I'm Nathan Hoerschelmann. The other good-looking guy is Gabe Dietz. We are thrilled and excited to have been invited to this conversation. Thank you, John. Now, if you want to have proof whether we're attorneys or not, ready, here we go, because I'm going to start laying out our disclaimers. First, while we are thrilled to have this conversation and to give some kind of general legal recommendations and kind of thoughts, we are not serving as your attorney. Happy to be your attorney, happy to work with you. Feel free to contact us offline. And then I know that a number of people always have questions, and one thing, and I think that anybody that's been to law school can attest to, the first word we're taught to answer any question with is the word depends. So while many of you may have a question for us, I'm not trying to punt, and we're not trying to be evasive by saying that the answer depends, but usually there's a whole bunch of different elements that may come into how we're going to answer that question. So we welcome any and all questions from you. Feel free again to reach us offline. Our contact information is going to be on a number of these slides, or you can put it in the chat box and we can get connected. But we also then have a limited amount of time, and we can only get to so much. But we have combined 27 years of experience. We've been working with and for a lot of photographers and small business owners and creatives. I have served legal counsel for
You're breaking up a little bit.
Something sitting in a speaker or microphone. Anyways, I've been working with and for ASMP for the last number of years. And so I'm happy to be part of this conversation and to walk through a number of different subjects. So some of the things that we're going to talk about, the current state of executive orders, the current state of phases in Washington State. We're then going to walk through a number of contract principles, some major issues that you want to look for in your contracts. We're going to talk some about force majeure provisions and cancellation issues. And then Gabe is then also going to talk about business closings and formation issues. We're going to try and do this at kind of a brisk pace, but excited to be part of it and look forward to being of help. Thanks.
Thanks, Nathan. And thanks, John, for having us on board.
Thank you.
Familiar faces out there. Let me just jump in. I'd like to talk about some practical considerations and then also the current status of the governor's executive orders. As you know, we're currently in lockdown. There are a lot of state and local orders out there. And this presentation is really geared towards Washington residents, but it does kind of serve as a general overview for what's happening with other locations as well. In terms of what's happening legally, at first I want to point out that right now courts are generally closed and relief is difficult. It depends on the county. For example, King County is pretty backed up. Courts were generally closed for a few weeks there, and they're just now starting to get to processing some types of filings. While you can still file a lawsuit, for example, process servers are a bit slower, and most motions and trials are also on hold. For example, in King County, you can't even get a default judgment right now. So we find that currently a practical approach works best. We've been working with a lot of clients trying to negotiate on their behalf. We recommend that clients work with their vendors and other parties proactively to try to modify their agreements and come up with a solution that really makes sense. And so I think that industry practice and generally what most parties are doing right now is to try to work together in a way that works for everybody. So clients mitigate damages. Don't just let this under a contract pile up. Work and think proactively. It's a good idea to document everything and communicate with other parties early. Reach out.
Hey, Gabe, are you bumping there's like a bump with the microphone, I think.
Yeah, I don't know where that's coming from. I'm not touching anything. Is there, maybe if
I'm not hearing it.
Yeah, I'm getting some feedback. Maybe if everyone else who's just listening could put it on mute temporarily, maybe we could get less feedback that way. Anyway, let me try to continue. So yeah, I always recommend that people communicate with other parties early, work with other parties under your contracts, talk to your insurance companies, work with landlords, creditors, government agencies, try to really come to a resolution early and avoid any conflicts that you can. We have on here, and I'm sure that most of you are aware of this at this point, but Governor Inslee has issued a letter. Let me just pull that up. This was on May 15th. So they basically categorized professional photography services and put out some advice in terms of what to do, especially with the phasing. As you probably know, there are phases 1 through 4, which each county has been categorized into. And right now, a little less than half of the phases have been, a little less than half of the counties have been moved into phase 2. Basically, phase 1 is total lockdown, and then phase 4 is pretty much returning to normal. In terms of the actual phasing, I can show you this map, which basically tells you, okay, the most populated areas are still going to be in phase 1, and those are probably going to be the last ones that come out of it. Most of the counties that have entered into phase 2 are low populated counties. But I think that for people who are operating in King County and Pierce County and other highly populated areas, this does provide a roadmap. The governor's order, which specifically relates to professional photography, which I think is good that they're thinking about this group of people specifically. It basically provides a lot of guidance. And I highly recommend reading through these documents carefully. They're not too long. This letter is only 3 pages, and it gives a lot of practical advice in terms of what to do with sanitizing, wearing face masks, social distancing, those types of things. And so once King County does reach phase 2, you'll have those ready to implement. See. The last thing that I really wanted to mention with these documents is that the penalties for violating these orders are somewhat steep. It's a gross misdemeanor, which is equal to at most 1 year in jail or $5,000 in fines. And I have not heard of any police issuing citations, but I am aware that the Attorney General's office is aggressively pursuing businesses that are in violation of the orders. So I think that there's a heavier risk if you're running a business and you're violating the orders versus maybe someone who is just going out to a park and taking some photographs. But there is a risk in any case, and I always advise clients, let's closely track what's going on with these orders and stay up to date.
And I think that the other thing that I think is really good, and this is good for practical business, is to make sure that you have your own COVID or pandemic plan of how are you gonna sanitize, how are you gonna keep models or employees or contractors or whoever is safe, and to have that plan and to put it out to people, put it out to potential clients, put it out to people that you're going to be working with, because that demonstrates a level of professionalism, a level that you know what you're doing, that you are taking all the steps that then a business that maybe doesn't want to track those issues or doesn't want to have to think about that, or an insurance carrier or whoever can say, oh, look, this guy is on, or this person is on top of their game and are handling these things seriously. And I think that, trying to be as proactive and demonstrate a level of professionalism, demonstrate a level of planning is beneficial for any and all photographers. Did you have anything else there, Gabe, about that section?
I think that things are changing. We put on a presentation last week and only 9 counties were in phase 2. At this point, there are 14 counties in phase 2, and more are eligible to apply for phase 2, which is good. I think that we're going to see less lockdown and return to at least business with modifications. I think it may be a while before we return to business as usual, but at least photographers will be able to start performing some services soon.
Yeah, great. Well, so one of the things, and I was talking about this with John, or Gabe and I were talking about this with John before this presentation started, and that was, one, we half joke that justice does not wait on any virus. So litigation and cases are still pending. Matters are still able to move forward. There's not been a complete stoppage of work, at least for the clients that we work with. But specifically as it gets to photographers, while the majority or almost all their shoots have been at least stopped or paused, it's been an opportunity for a number of our clients to then reevaluate their own agreements, their own contracts, and to look with some real intent of what is in their agreements and to kind of do a reassessment of what is working for them and what isn't. So we've been able to work and kind of revamp a number of contracts and agreements, service agreements or independent contractor agreements for a lot of clients and for a lot of photographers, and that part has worked out well. So what we're going to do is now give a quick kind of walkthrough about contract basics, what the general purpose is, what the components of a contract should be, and then talk some about modifications, amendments, and then some provisions that we think are important, particularly now, to make sure that you have in your own contract, right? So what is the point of a contract? The point of a contract really is to lay out a clear understanding of expectations and duties for 2 or more parties, right? Are contracts important when things are going well? Sort of, but nobody usually cares when things are going well. Contracts really come into play, and the strength of them really come in for when things are going wrong, right? And that's when people can then turn and have an understanding of, oh, if something is going wrong, what are our recourses? What do we do? How do we dispute? How do we have a dispute resolution? What happens next? We always like to think of that a good agreement should be able to be read by anybody. Think of a judge or a jury or some independent reader of a contract and know clearly what has been agreed upon between the parties. Can there be oral agreements? Of course. Can there be oral modifications to agreements? Yes. But if things are breaking down and things go all the way out to some formal conflict resolution, more often than not, looking at documents, looking at evidence that has been written down tends to carry more weight, right? So, and now also, of course, memories can fade over time. If you get into a fight over oral agreements, then it's a he said, a she said, that can be problematic. So the best thing to do is to have a clear and understandable agreement that all parties have a clear understanding as to what their duties and expectations are to one another. So what are the basic components of a contract, right? One, there's the parties. Who's involved in this contract? Who is the contract between? 2, there's going to be a scope. There's going to be some description of the services or work or what is being agreed upon. 3, there's going to be the terms of payment, right? Contract or photographer typically wants to get paid for what they've done. 4, we think it's always important to have a termination clause. There's got to be some way that if things are going sideways or things are not working out for the parties, how can the parties separate from one another? It's always the old adage of, at least as it relates to business, it should take a long time to figure out who your business partner is. It should be a short amount of time to figure out how to separate things. And that take a long time to get into bed with one another, but have it be a short amount of time for that termination if needed. Nobody wants to have the lingering issues or asking for their AC/DC t-shirt back years later. Dispute resolution. You want to lay out a clear roadmap for how, if let's say we do have a problem, let's say we do have some issues, how do we go about resolving those issues? And I think laying out, whether it be mediation, whether it be arbitration, whether it be litigation, whatever it is, or whether that there's going to be a vote, who's the tiebreaker vote, you should really try to think, and I can say this from personal experience, even with Gabe and I, as we were forming Hoerschelmann Dietz. Gabe is a great and very reasonable man. I'm also a great and reasonable man. But we also recognize there may be moments in which one of us feels though there's going to be some reasonableness. So it's really important to make sure that you have a well thought out dispute resolution plan and that is figured out with your whoever you're doing work with. Then, and this is where my years of doing insurance defense work really kicks in, indemnification provisions. Indemnification, indemnification is a, how do I want to politely say it? It's a powerful word. So indemnification in essence is where you are switching the risk from one party to another. So if you are doing work as a commercial photographer and you're working with a large company, I can guarantee you they will have an indemnification provision in their agreement. And that is where if something is going wrong, that party wants, or your client then wants you to step in their place and defend them or hold them harmless or in essence protect them. So you want to make sure if you see an indemnification provision that you know which way the risk is being transferred and you have a clear understanding about it. Trust me, we are more than happy to walk through that in more detail. Then also, and particularly as it relates to photography, right? A work made for hire provision. If you have a subcontractor, if you have an independent contractor who's working for you, you probably want a work made for hire provision with them. If you were doing work for somebody else, you likely do not want a work made for hire. But again, and with all of this, it is very, very rare that there is an absolute right or an absolute wrong answer. More often than not, you're having to put your decision-making on a risk-reward sliding scale for yourself. And does it make sense for me to agree to work for hire in this capacity? Or maybe it does and maybe it doesn't. Then make sure that you have your releases figured out for if there are going to be any models, there's going to be any property that has been figured out. And then again, as we tend to represent, most of the time we represent photographers. We always want our photographers to get paid. We want to make sure that they get as much of them paid as possible at any point in time. So if there are any disputes about a invoice, we want there to be a disputed invoice clause and late payments clause. We want what is not in dispute for the photographer to get paid for. We always try to make sure and add some teeth to our provisions that if a client is going to be late, that there are late payment fees or penalties. We want, again, the enticement is pay our client on time and then everybody is happy. Then obviously there's always then questions of jurisdiction. You want to make sure that you have the right jurisdiction for what is going to be the choice of law. So if you are a Washington photographer and you're going to be shooting work in Washington and you're doing this on behalf of a California big company, they may have in their agreement that if anything goes wrong or if they want jurisdiction to be California. That's not going to be in your best benefit. So you want to make sure that jurisdiction, if you can, is more in line with where you are and what is convenient for you. And then of course, signatures, acceptance from the party. You want that to be documented as well. Okay, as it relates to modifications and amendments or changes, because certainly for a photo shoot, there are never, ever changes. That's a joke. There's always changes. There's always changes to a project. There's always changes. Make sure that you are committing any of these changes to writing. If you can redo the agreement or add it to the agreement or make an amendment to the agreement, great. If you can't do that, at least put it in document it, whether it be in email form, whether it be in text message, whatever it is, find some way to make sure that you have a documented agreement to whatever these modifications or changes are. I know that can feel cumbersome. It can feel time consuming, or it can feel as though you're breaking up the flow of your work with this client. In the end, it still is the best thing to do for yourself and to protect your work. Okay. Force majeure provisions. Force majeure provisions. These are incredibly important right now, right? A force majeure provision is when there is a situation in which it is outside of any party's control and there is going to be some alleviation of the duties or the responsibilities to one another. Now, the devil is always in the details, so how these force majeure provisions are written are always critically important. So typically you'll see things like, if in the case that there is something that has happened, whether it be act of God, whether it be war, whether it be famine, whether it be pandemic, government shutdown, terrorist attack, there's usually a number of items that are listed over and over and over again. If those things occur, then certain expectations or duties are relieved. I think it's important, if you're a photographer, that you want to make sure that you are protecting yourself as much as possible, so that in the case of a force majeure scenario, that any and all reasonable or any and all out-of-pocket expenses up until the time of that force majeure event happens, that you should still get paid for. You should want to make sure that you're putting in provisions that are protecting your work up until that point, and make sure you're not left on the hook for anything if suddenly you cannot perform your duties. You want to, like, just because it's going to be just because of economic hardship, that's not going to relieve you of your duties. You need to be able to say that something has completely prevented you from being able to perform this work. There's other things that you can look at for frustration of purpose, or impracticability, or impossibility arguments, if there's other ways in which that you are needing to show or demonstrate that you need to be able to get out of a contract. But the force majeure provision is certainly one that is pretty standard, and you want to make sure that you have those in your agreements. I could sit there and say that there was a client that we did some work for, or that we've been doing work for years, and he had a large international auto company. And this happened even just this spring, and he was set to do a series of shoots, and 2 days, they had an agreement in place. 2 days before the shoot was supposed to start, the other side attempted to put in a force majeure provision that would relieve them of having to do anything, and tried to throw in the words pandemic. And it was a last minute effort that it didn't quite work, because we ended up still getting our client paid for what he had performed thus far. Anyways, in terms of cancellations of course come up all the time. You want to make sure that you have that well articulated in your agreement of what happens in a cancellation, or what constitutes a cancellation. There could be either a mutual agreement, that both parties mutually agree on a cancellation, and what happens then. There could be termination for cause or convenience. And then again, we always want to make sure that we are protecting our client and protecting the photographer, that they're getting paid. So we have then a disputed invoice clause, and then also again is the dispute resolution process, and that should be laid out. Those are big considerations that we have at the moment that we tend to find ourselves working through over and over again. We also then are making sure that any of our clients that are now revamping their agreements are making sure that these sections are included and that they're worded in a way that puts our client in the best position possible, right? Certainly there's an impact right now. There's a number of entities, and whether it be that this pandemic is forcing companies to shut down or is opening a door for this might be the right time to shut down. We've had a number of clients and a number of people ask about business closings and what that looks like and what are some good considerations. And so for that, I'll turn it back to Gabe.
Before we do that, there's some questions coming in the chat. I'd like to just bring those up. From Jim,
Sure.
Is there any indication of how courts are dealing with problems arising from contracts that didn't anticipate these situations?
Well, so again, ready? Here's the first statement. It depends, right? It depends on a number of different factors. It depends on the state, depends on the jurisdiction, depends on the scenario, depends on the communications maybe you've tried to have with whoever you're dealing with. So that there's a lot that goes into that question. So we have not had much case law on point, certainly dealing with COVID yet, but those will begin to come into play. I imagine that those are going to be trickling in fairly shortly.
I would also add to that. Yes, generally it's difficult right now, as I discussed. Courts are closed. There's limited remedies available. As Nathan sort of touched on, we just don't have a lot of case law on force majeure that's applicable to a situation like this. Courts haven't really dealt with a pandemic before. But with that said, I think that it's important to read your agreements carefully. You want to see if there are any termination for cause or termination for convenience clauses if you're looking to get out of the agreement or modify it in some way. Also, it's really important that you take a look at your agreement to see if there's a force majeure provision and see exactly what types of situations it applies to. It's really a two-part step. You look at your agreement and see if it applies to the general situation. If your agreement mentioned something like pandemics, which unfortunately it probably won't because a lot of agreements aren't drafted that way. But if it does, then it probably is more applicable to the situation. Then you also want to look at the clause to see what relief does it provide? Does it state that a party can get out of paying something, for example? Does it state that the party gets an extra amount of time to perform the agreement? We've helped a lot of clients with these. If you'd like us to take a look at your specific agreements and help with redrafting, we're happy to do that. Or if you have an agreement and you need some advice on how to navigate it during this time, we can also provide some specific advice that's tailored to your situation.
Great.
So that also then gets to one of the questions that's there is there a standard definition of force majeure, or do we need to specify the specific conditions in the contract? The basic answer is no, there's not a standard definition. There's kind of a general statement of force majeure, but then what specific elements are defined in that use for the contract are then in the contract itself. So it's really, again, that's where one of like the profound moments I had working with creatives is I was dating a photographer years and years ago, and I would sit with her and her friends, and they would explain that, hey, we found ourselves in some situation and we have some issue. And I would run through a series of questions of, well, was there a contract? No. Okay. Well, was there a contract? Yes. Did you read it? No. Okay. Was there a contract? Yes. Did you read it? Yes. Did you understand it? No. Okay. So the devil's in the details, and it's really good for you to know, to have a clear understanding of what these different provisions are. And some of it, I mean, the joke is that it's written in legalese, right? And it's written in a dense way that, only a soothsayer could figure it out. All those things are kind of half-truths. In the essence, at least how we work with our clients is we want to make sure that our clients are empowered with their contracts and have a full understanding of what their own terms and their own provisions mean. So when we draft a contract for a client, we then want to make sure, and we sit down with them and, hey, let's walk through this, make sure you know what you're talking about in your own agreement. Every photographer, any party should have an understanding of their own agreement. Now, will you always be able to use your own agreement? Maybe not. Oftentimes a large commercial entity or a commercial client want you to use their agreement, probably. And if you don't understand any portion, you should ask the questions, whether it be ask an attorney. I know of two good ones. Pause for that. Or ask them what that provision means. But either way, that's where things get really murky and people can find themselves in a jam, because some of these agreements are very specific and some of them are more general. So that's a long-winded answer, but that's what I got.
Great. Well, let's see. Melissa's out in Michigan. She knows each state is different, but Michigan opened retail on Tuesday by appointment, and it's vague as to what that means for photographers. Do you have any idea if she can conduct business or how she can find out?
Well, since we're not licensed in Michigan, I want to be careful. I do not know how Michigan operates. I would think, it's one of those things that you can take politics aside. I appreciate the efforts that our state has gone through to try to navigate this very weird scenario. So I would hope that Michigan would have some outlined instructions or understanding as to what is working, or if they have phases or if they have standards. I would hope so. I certainly know that for Washington, our guidelines have been helpful for us.
Yeah, it looks like your guidelines are great. Ours are very murky, and I added on the bottom, while they're open for business by appointment, the governor extended our stay at home for 2 more weeks, yet we're still conducting business by appointment. So it's just really confusing. There's nothing really clearly defined. It seems the rules change all the time.
And I think that is going to be the case. So I don't foresee that as necessarily changing anytime soon. I think whether it be the PPP, whether it be phases, whether there is going to be a second wave of this virus, if anybody says that they know exactly how this is playing out, do not break eye contact, but walk out of the room slowly, because nobody knows. But the best thing, do the best that you can. Try to follow the letter of the law if there is something that is outlined, and that's the way we navigate. And again, I think that if you then, as a business owner, are then filling in the gaps for yourself of, hey, this is how I'm going to approach COVID, or this is how I'm going to approach a pandemic. This is my action plan. These are my safety precautions. These are how I'm going about it in a way to keep my clients, my employees, myself safe. And you have that well outlined, then that it doesn't absolve you of any potential liability, but it certainly lays out like, hey, listen, I've been forthright in communicating what I'm trying to do and how I'm trying to go about it, and showing that I'm taking this very seriously.
Thank you.
So Ian is asking if you recommend a specific hold harmless clause in regards to COVID-19.
We have certainly drafted some waivers to be added to insurance policies, as well as other language for working with independent contractors or working with clients. And I think happy to have a specific conversation with people if they would like to, but I think that it makes sense to do so, yes.
And this is kind of leading into the next part about starting businesses. Maybe Ruth is asking what the differences between an S Corp or a C Corp or a sole proprietor LLC. Is an S Corp better for regarding taxes? And what about bringing her daughter in as a partner? So I think that goes into the next section anyway.
Yeah, that's a great question. I was going to talk about business closings. I'll get to that after business closings. And then,
okay.
Just remind me if I forget to discuss anything, but I will cover that. So let me just, this isn't going to take very long to run through business closings. and this issue has come up for a few clients that we've had. A lot of people have questions about what they need to do in order to close down a business. They're thinking about making a change or shifting gears at this point. There's just a few steps that you'll want to follow. I should mention a caveat. It's always really good to have an attorney on board with these types of situations, because some of the steps are a little bit tricky if you haven't done it before, and we've helped clients with that in the past, so feel free to reach out. But the first step is you need to do some type of corporate resolution, whether it's a limited liability company or a corporation. Limited liability companies have operating agreements. Those are the agreements in place that define all of the rights and obligations between the owners or the members of the company, and also the managers, who are the people who are in daily control of operations of the business. Corporations have bylaws. Those are analogous to the operating agreement for a limited liability company. In either case, you just want to take a look at the agreement to make sure that you're following all the steps that are laid out in order to close the company down. And then you're going to want to make a corporate resolution. You want to do some type of company vote, typically under the bylaws or the operating agreement. And then you're also going to want to record that decision and possibly also execute a corporate resolution that outlines the steps that you're taking in order to wind the company down. In Washington, we have our Department of Revenue. You want to notify the Department of Revenue and let them know that the company will no longer be in business at a certain date. Submit and file your final tax application. This really depends on the type of business entity that you have. If you have a corporation, you're going to need to work a little bit more closely with the Department of Revenue in order to get that done. Next, which is the major step, is to file articles of dissolution. Those are the documents that you fill out and you file with the Secretary of State that you're dealing with. In Washington, we would just file it with the Washington Secretary of State. Basically provides all the company information and states that the company is no longer going to be in business as of a certain date. You'll also want to cancel service with any registered agent that you have. Registered agent is the person who is authorized on behalf of the company to accept legal documents such as papers for service of a lawsuit. If you had another person or a company, a lot of companies will serve as your registered agent for a small fee. You want to work with them to make sure that you're following their steps and notifying them. One of the other important things to do is to notify any creditors that might have a claim for the business, if you have any loans or anything like that. And in Washington, there's a specific statute that you can follow. Most states have analogous statutes that you can follow as well. And these allow you to provide a certain number of days notice. For example, in Washington, it's 120 days. You basically send a letter to the creditors telling them that you are winding down the business, and if they want to make a claim against the company, they need to do it within that time period. Finally, in order to wind down the company, you'll want to basically pay any debts that are owed, and then you'll also want to liquidate any assets, distribute those to the owners after all your debts are paid off. In terms of tax consequences, we always recommend that people consult with a tax expert or a CPA. But the simple answer is that your tax responsibility for any gain that you had in the business is going to be based on your basis, whatever you put into the company. So you may have to pay some taxes if you had some capital gains when you're going about liquidating the business.
Okay.
So I think that's John. Did you have any questions from anyone about that? I think I'll just lead into business formations if we don't.
Yeah, we had the one question that I already asked, and then there's a question about a contract that we can look at see if we can help
Okay.
Lynn out.
Okay. Well, let me just jump into business formations. I'll run through this pretty quickly. We'll have time for questions at the end, I believe.
Yes. Yes.
So business formations, some people think that doing a filing is maybe the first step to starting a business. I think that really the first step, though, is writing a business plan. I always recommend to clients, and we've helped many clients with writing their business plan. And I think it's really important to write one because it has so many benefits. It's a communication tool for all of the stakeholders in the company, owners, investors, anybody who is going to provide services such as insurance or bank accounts, accountants, future buyers of the company as well. It really helps everyone get onto the same page in terms of what the company is going to look like, what type of business it's going to be, and establishing a long-range plan for the business. In a business plan, we at a minimum like to see a business description, the name, the location and geography that the business is going to be operated in, the types of projects and services that the company is going to pursue, what type of business environment and market is the company going to be competing in, and also what type of competitors exist, how do they run their businesses, and how can you do your operations better than they do. You're going to want an operations plan, talk about what types of equipment you're going to need, travel, any vendors, what types of accounts, insurance, software, and obviously if you need an office, where is the business going to be located. And then finally, a financial plan is always a great idea. It's good to have a pro forma and figure out what basic numbers are going to look like for the business before you get it started. Most photographers, in terms of the type of business entity that they run, there are maybe 4 or 5 that people consider. A sole proprietor is the default rule. If you just start operating as a photographer and you don't have a business entity, the law will classify you as a sole proprietor. All of your contracts and agreements are going to be directly between you and any companies or other people that you're dealing with in that scenario. At the opposite end of the spectrum is a full C corporation, which is it is the most complicated. It takes the most amount of maintenance. Corporations have bylaws that are much longer than an operating agreement in an LLC, for example, and they have shareholders, which are the owners, and typically a board of directors in order to manage the day-to-day operations and appoint the officers and directors as well. Obviously, there are tax differences between those entities. The sole proprietor, all of the income and expenses are going to be allocated directly to that individual person. With a corporation, we have double taxation, where the corporation is going to be taxed once on its profits, and then the distributions paid to shareholders and employment agreements and income that way is going to be also taxed to the individuals. So those are kind of the 2 opposite ends of the spectrum. Between that, you have things like limited liability companies and subchapter S corporations. A limited liability company is a relatively new creation. Most states adopted these in the 1980s, for example. And case law on them is not as well developed, but the benefits of them are numerous. Basically, a limited liability company is treated as a partnership. There is pass-through taxation for tax purposes. So the limited liability company will not pay taxes on its profits, and all of those will just be allocated to the members of the company, typically in proportion to their ownership percentage. So if you have a business with a partner and you want to form a limited liability company, you can easily agree to split profits and losses 50-50, and each of you will just be allocated those profits and losses when it comes tax time. A subchapter S corporation is also a type of corporation, so it's going to have more management and maintenance responsibilities. There are bylaws, but a subchapter S corporation is also treated with pass-through taxation. It's beneficial for some people who want the benefits of a corporation as they are starting and running a business and having those formalities for things like officers and directors and managers. But they want to have the pass-through taxation. And there are a lot of requirements. So if you're thinking about forming a subchapter S corporation, I'd recommend that you talk to an attorney. There are only a certain number of shareholders that can be allowed. There are certain meetings that you have to comply with. There are a lot of other requirements as well. But typically, most photographers, I would say, I recommend that they form a limited liability company. So I will talk a little bit about limited liability companies here. I'm not going to get into corporation formation too much, but there are a lot of analogous steps if you're going to be forming a corporation. In terms of starting an LLC, the first step is to do the filing with the Secretary of State. In Washington, we file articles of organization with the Washington Secretary of State, and you'll need to provide a lot of information about the company to get it going. Your name, social security number. You need to have all the addresses for the company, such as mailing and business and the members and managers' contact information. You provide emails and obviously a registered agent, which we discussed a little earlier, is the person who's authorized on behalf of the company to accept the paperwork and other filings, such as lawsuits that have been filed against the company. The next step is to write an operating agreement. Again, this is the document that governs the rights and responsibilities of the members, which are the owners of the company, and possibly managers, if you appoint managers in order to manage the day-to-day operations. The operating agreement will want to spell out a host of different things. Initial contributions by members are important. Voting rights, whether or not the company will accept new members and how to add them. If the members and managers can't agree on a certain thing under a vote, we always want to have a deadlock breaking mechanism, such as a neutral third party breaking the vote, or possibly mediation or arbitration. It'll deal with whether the company has employees and independent contractors, possibly deal with any insurance information that the company is going to need, any licensing and permitting, business offices. As we talked about before, it's always important to discuss how profits and losses are going to be allocated to the different members of the company. So you want to have a comprehensive section of the operating agreement that discusses how those are distributed. And then finally, one of the really important things that we always talk about with clients is transfers of interests in the company, how that will happen if there is a death of a member, for example, or if a member just wants to go ahead and transfer the shares outright to another person. Will there be rights of first refusal, for example? Will there be some type of valuation process in order to buy people out? Those are the main things that are important for an operating agreement. The next step is you need to file an employer identification number. That's the IRS number that is assigned to your business. And each business needs one. You also want to look into whether or not there are business licenses that you need to apply for. For example, if your business is located in Seattle, you need to apply for a Seattle business license and pay annual Seattle business taxes. And then finally, one more consideration is if you want to register any assumed business names. Let's say you call your company, Smith, John Smith LLC, because that's your name, but then you want to operate as, some other type of photography name like Excellent Photography, or I'm just coming up with something random, but if you want to operate under that business name, you need to register it with the Secretary of State, and that's a pretty easy.
Is that pretty much the same as a DBA?
Yeah, that's also known as doing business as.
Okay. So let's look over at the chat. Jim is asking, in general, what are the benefits of having a registered agent for a small business?
Yeah, that's a great question. Well, if you are not a sole proprietor, if you are any type of business entity, if you have any type of business entity, you have to have a registered agent. And the simple answer for most photographers is that it can be you. If you own a Washington limited liability company and you just assign the business address as your home address, then it makes sense to just use yourself as the registered agent. If you have a company that you're forming in Nevada because your CPA told you it's a good idea and you have multiple members living in different states, then you'll need to have a designated office in Nevada, and you'll also need to have a designated registered agent in Nevada. And there are a lot of companies that can serve as your registered agent for a small fee. Usually it's $100 or $200 a year for them to do that. But you do have to have a registered agent in the state where you form the business.
Certainly, you can do it, as Gabe said, you can be your own registered agent. It's usually recommended that it's either an accountant or an attorney, in that if for no other reason, then it takes you a little bit off the hook, that if something comes in, it's not responded to, that you can turn to your registered agent, be like, hey, how come you didn't let me know about this? But in essence, it just is, it's a way for the state or anybody that needs to get a hold of you, whether for tax issues or litigation or whatever it is, that they know they have somewhere they can go to. So.
Yeah, I should mention that when we assist clients with forming business entities, typically we will serve as the registered agent after the business is formed. So we will receive any documents directly, and we know how to deal with that right away.
Great. Do you have any opinion on arbitration clauses?
I'm not a huge fan of arbitration clauses in general, but again, the answer is going to be, it depends.
It depends.
Right? So it depends on your business, depends on what are the projects, what are the agreements for, like what kind of work are you doing typically. I am a believer in general for ADR, alternative dispute resolution. I'm a fan of mediation, in that I think anytime there's the ability for the parties to kind of control their own outcome, I'm usually in favor of that, right? So in mediation, all the parties have to agree on whatever that final resolution is. And the joke is that, the half joke, I mean, it's half true, that a good mediation leaves everybody a little bit unsatisfied. Whereas with an arbitration is essentially litigation, but on much less formal. I would rather, in general, I like having a mediation provision that parties first have to mediate in good faith. Those mediation costs are shared between the parties. And then if that is unsuccessful, then the parties can go to litigation. But I like having then an attorney fee provision that the prevailing party is entitled to attorney's fees, because that leaves, it's not uncommon for, we've had a number of clients who are photographers dealing with a big commercial entity. They've either not paid a client or kind of jerking the client around, and it's for maybe $1,000 or $2,000 or $5,000, but not in a massive amount of money. And so the client, or our client, then feels like, hey, what's a way for me to get these people to actually pay? And if there's an attorney fee provision, the prevailing party is entitled to attorney's fees. Trust me, that is a huge hammer or a huge stick to bring into the room and to say, hey, look, you guys can jerk us around all you want. In the end, we're going to win, and we've got this, and you're going to have to pay for all my fees. Usually that speeds things up. So that's, again, general answer.
Yeah, I would add to that. Yeah, it really does depend on the specific situation and the client, as Nathan mentioned. But in general, arbitration, at least in theory, is supposed to be faster and less expensive than court. I think the main drawback of arbitration, which I learned early in my legal career when I was a young attorney, working under other corporate counsel, we had a case that we were working on where the arbitrator, really, it was just a bad result for our company. And the arbitrator pretty clearly decided in the other party's favor against us. And it was probably not the right decision. The drawback with arbitration is that it's not appealable. So the decision of the arbitrator is generally final. In court, you can go ahead and appeal the decision. The CEO of our company at the time thought that it'd be a good idea to, go ahead and challenge the decision. He really felt that it was just a completely unjust decision, which I felt like it was too. So we attempted to appeal it at the federal court level, and they just denied the motion and unfortunately hit us with some fees for the other side in order to oppose our motion. So arbitration, you're stuck with the decision, but generally it's faster and less expensive than court.
So I'd like to go back to Lynn's question and just see if we can help her with at least a general answer about a wedding photographer that's charging $1,000 to transfer a canceled wedding because of COVID to next year.
That's pretty hardcore. I mean, without, again, do I think that that's the right move for that photographer? Man, that does not sound like a good business. That doesn't sound like a good business practice. Again, the first thing that we would do is you turn to the agreement and what provisions are in there. Are there cancellation provisions? Or are there term? Or if this photographer is really wanting to hold to this transfer fee, then I would look next to like, well, this doesn't sound like the right photographer to work with, and what are the termination options, and how do we switch photographers, because that doesn't sound like the right person to work with. Again, there rarely is there an absolute right or an absolute wrong answer. In general, you need to make your own best decision based on your own risk reward or business practice spectrum, right? Of what is going to be good for my business, what is the right thing to do. Gabe and I, we really take great pride in working with our clients and talking with them about and having them articulate what are their needs, and then some of their needs that are unarticulated, and we can kind of figure out with them what is it that really is important for you. And then ultimately, you're the captain of your own ship, and we can make any recommendations in the world, but ultimately you have to make that final decision as to what you want to do. So in this case, does that sound like a fair way for this photographer to operate? Man, that's pretty hardcore to throw in a rescheduling fee of $1,000 for something that's outside of everybody's control. But again, that's their business decision to do it. It sounds like they probably should work with somebody else.
Yeah. So, and Lynn's also saying there'll be no refund of the deposit if she leaves this photographer, and she would still owe the balance. So it's, yeah, she's being really hardcore.
Yeah, I mean, I think there's, ultimately, I'm a somewhat believer in karma, and I think that will circle back. Or I think if you have that reputation of being a photographer who's going to unnecessarily charge for these kinds of things, it'll come back. It'll come back.
Yeah.
It
Well,
probably depends on the language of the agreement, but I mean, there are some arguments that you could make that may be a little bit weak, but you could argue that the agreement was unconscionable, or that as a liquidated damages provision, that clause just is unenforceable. Happy to talk about those items offline. We'd really kind of have to get in depth of what the agreement says and what arguments you could make.
let's just finish up with one more from Jim. I think this goes back to registered agent. What if your home is in your spouse's name? Can you use a P.O. box? And what might you charge for being a registered agent? And how much would you charge for stalling the feds while I run for the border? He's asking for a friend.
I'll let Gabe take the last one. No, just kidding. Yeah, I don't think that you can use a PO box. I can't remember. I think you can use a PO. No, you cannot use a PO box for a registered agent, right? I think that it has to be a physical address. I just cannot remember off the top of my head.
Yeah, I think it depends on the state, but in Washington, I think in all West Coast states, it cannot be a PO box, because I've done LLC formations in Oregon, Washington, and California, and I don't think I've ever appropriately used a PO box, but it does depend on state law.
And so for the spouse's name in the home, that doesn't matter. Like that doesn't have any correlation to one another, for at least for the registered agent. How much do we charge for the registered agent? To be honest, like typically we're already working with the clients. We've never had anybody that we don't work with just come and ask us to solely be a registered agent, but I'm sure we can figure that out. It'll depend. Oh, nice. That's a nice way to wrap it up.
Cool. Well, I want to thank you all. This was great. Got a lot of information out there. Getting a lot of thank yous over in the chats too. Is there any final words you want to add to this?
Just that these are really challenging times, and I think that having communication, I think trying to work through this, whether it be as if you're part of an association, or whether you're part of a community, or you follow along with a photographer who's experienced and knowledgeable like John, whatever is best to help you kind of gather your information. Ultimately, that's what we're supposed to be here to help you with. So we appreciate the opportunity, John. Thank you so much for inviting us. And we look forward to talking to any and all of you and being of help however we can.
Great.
It's really important to reach out to groups and other people during these times, I think. I mean, really, really lean on your support groups, and try to stay involved in organizations. I've heard scientists make the point that perhaps the phrase social distancing is wrong. Maybe we should call it physical distancing, because social interaction is a really important part of human health and welfare. And I think that, you really need to reach out and talk to other people and see what other people are doing with their businesses as well during these times.
Great. Well, for my side, next week I'm going to do a class on an introduction to Studio Flash on Monday. And let's see, on Thursday, June 4th, Jen Rosenbaum is going to be my guest here. Jen's a boudoir photographer and cancer survivor, does a lot of work for women. And then on June 8th, I'm going to talk about lenses. June 11th, Matthew Jordan Smith. And then June 15th, Bambi Cantrell. So I hope you can join us for some of these coming up. Until then, I want to thank you all for attending, and I'm going to close this down now. So thanks all.